February of 2021, an officer in New Mexico made a traffic stop of a Mr. Ross Sanders. Mr. Sanders was operating his motor vehicle with a suspended license. Therefore, Mr. Sanders was, of course, arrested. Now, because the officer stopped Mr. Sanders on a public highway, lawfully possessed the vehicle, and was now responsible for that vehicle following his department's policies and procedures, the officer decided to do an inventory of the vehicle. The officer initially looked in the vehicle as he normally did, starting at the front of the vehicle and working his way to the back. Nothing notable was found. Anything of value was simply notated on the inventory sheet, as they do in every inventory, because officers do an inventory to protect themselves from claims of loss and to protect the suspect, the defendant's valuables that has just been arrested, because we're not going to leave their stuff in public where it can be broken into, and we want to make sure there's an accounting of that stuff. So at any rate, officers called for the tow truck, and another officer came on scene when the original officer had drove Mr. Sanders to the jail. The other officer began to finish the inventory and looked in the trunk of the vehicle, where he found a small zippered black pouch. The officer opened the zippered pouch and found methamphetamine and paraphernalia. Mr. Sanders was then also charged with, in addition to driving on a suspended license, possession of methamphetamine and drug paraphernalia. Now, under the Fourth Amendment, this is a lawful inventory. The officers had lawful possession of the vehicle, i.e., by arresting Mr. Sanders, they sort of made that vehicle and put it in a position where it could have been broken into, it was in a public place, and also the officers themselves could have been liable from claims of loss or stolen property. They were following their policies and procedures. Their policies and procedures allowed them to look in a zipped container. There is ample Fourth Amendment case law that allows an officer to look in a container during an inventory. This is lawful under the Fourth Amendment. However, folks, this is not a Fourth Amendment case. I'm talking about a brand new case for my New Mexico officers from the Court of Appeals, State versus Sanders. We're going to talk about the inventory exception under New Mexico law. If you're a New Mexico officer, you're not going to want to miss this episode. I'm going to break this case down for you. I'm going to tell you what the Court of Appeals explained in this landmark decision for search and seizure, State versus Sanders. We're going to talk about it right now. What's up, everybody? Welcome back to the podcast. I'm attorney Eric Scramlin, and this, of course, is the Tactical In-Service Podcast. This is a podcast for law enforcement where I break down training topics and case law to help you, the law enforcement community, stay up on the law. Well, guys, it's been a minute since I have done an episode, and I apologize for that. We've been so busy. We've been busy because you guys have been bringing me in to do training, adopting this new philosophy that we got to learn the law just like an attorney does. So I appreciate that. Got to get back in here, got to get some episodes. This is a big one. This case came out on January 17, 2024. Disclaimer, this is for my New Mexico officers, but my other officers don't go anywhere just yet, because a lot of videos are planned for the channel this year. Going to be talking about a lot of topics that do apply to most states under the lockstep approach, where we discuss Fourth Amendment issues, Fifth Amendment, Sixth Amendment, all kinds of stuff. Got a lot of stuff planned. So hit the subscribe button if you have not done so already. Got a lot of stuff to cover. New Mexico officers, if you haven't done so already, you got to hit the subscribe button. All right. Again, disclaimer. If you are an officer from another state, just be glad you're not a New Mexico officer. This case is going to apply to my New Mexico officers only. This is a very unique thing that we're going to be talking about here. If you're curious, I would tell you to stick around, because this case is going to highlight how New Mexico, under the interstitial approach, gives far greater protections under its state constitution than the feds do. And that's what we're going to be looking at in this case. So let's dive in. Before I dive in to State versus Sanders, let's do a quick review. So let's hit the PowerPoint here. Let's do a quick review. So let's talk about the inventory exception as we've come to know and love it. And let's start with a Fourth Amendment analysis. Under the Fourth Amendment, there's essentially three things or three prongs to an officer, making sure we establish these three things in order to have a lawful inventory under the Fourth Amendment. Those three things being, number one, you as the officer have to have lawful possession of the motor vehicle. And I'm going to use motor vehicles for this example. Inventory would apply to a purse or a backpack or, any personal property that anyone would have. But I'm going to stay focused on the context of the automobile for these purposes of the case that we're talking about today, because specifically the fact that it's an automobile is a big part of the case. So let's focus on the automobile. All right, number one, you got to have lawful possession of it. So, for example, what the courts talk about there is by virtue of you arresting this person, essentially, did you render it unsecure? The context of that comes up most frequently, is it in a public area? Because if it's in private property, we just saw in United States versus Ramos that there's a whole another analysis there. The courts are beginning more and more to focus heavily on the community caretaking role that the inventory exception lives under. You're not supposed to be looking for evidence of a crime. So when the courts look at prong number one, even under the Fourth Amendment, lawful possession means, officer, did you lawfully arrest this person? Is it in a public area? Is it a public safety risk? Is it a public nuisance? Do you now have possession of this vehicle and it is your responsibility? So we're not going to leave it on the side of the road where it can be vandalized. We're not going to allow ourselves as officers to be subject to a lawsuit because we didn't check the vehicle. We didn't open the purse in there to see if there was any money, and now they're claiming that you stole the money. So it serves two purposes. Number one, to protect you from claims of loss. Number two, to protect the person you just arrested's property, because we're now responsible for it. And I'm saying as you as the police officer. So that's what they mean by prong number one. You have to have lawful possession. Did you render it unsecure by the arrest? Prong number two is probably the biggest area of litigation that I experience as a prosecutor, and that is, what is your policy, officer? Do you know your policy? You got to be familiar with it. You have to know it. I would have my officers literally bring the binder to court and read the policy to the judge and say, okay, did you follow policy in this case when you searched that bag in the trunk of the car? Yes, I was following policy and procedure. Good to go. We've covered it. The courts have said again and again, if your policy covers it and you follow it, you're generally good, as long as we have case law on it. And there is Fourth Amendment case law that would allow an officer to look in a locked container, zipped container, any container, because that's where valuables can be placed. And then finally, number three, is it has to be reasonable. This is the touchstone of the Fourth Amendment. All searches must be reasonable. That's exactly what the Fourth Amendment requires, and the courts harp on that. In this context, when we talk about reasonableness, we talk about your community caretaker role. What was your intent? Was this pretextual? Did you stop this guy with a suspended license because you had a feeling he was involved in drug trafficking, but you couldn't find a way to get into the car? So you used the fact that you knew he had a suspended license, you waited for him to drive, you stopped him, it was pretextual. Those are no good. Can't do it. Even federally, we see case law. Non-pretextual, non-investigatory purposes. Inventory is a community caretaker role. It was designed so you as an officer can protect yourself if they claim you stole something, and to protect their property because you now have it. It's got to get impounded. It's going to a tow lot. So it serves both things, and that's a community caretaker function. And these are the three prongs federally under the Fourth Amendment. What I said in the intro, this case, State versus Sanders, even our courts admit this is an easy pass under the Fourth Amendment. Officers lawfully stopped the vehicle. The person was arrested. Car's in a public area. There was nobody to turn it over to. Officers followed policy and procedure. They looked into a zipped bag in the trunk of the car, found drugs. This is no issue whatsoever under the Fourth Amendment. However, we're now going to go into the New Mexico aspect of the law. So this is where I want to remind you guys, I did a podcast on State versus Jim. I'm going to have it scroll up here. You may want to take a minute, pause this, and take a look at State versus Jim. I'm going to give you a brief recap of it right now. But State versus Jim is the first prong in how we get here. So now I'm switching gears. You guys know, as New Mexico officers, some officers from other states, some states do this as well, but primarily New Mexico is unique in how far they take this approach, which we call the interstitial approach. Fancy legal language. All it means is that courts can start with the Fourth Amendment and say, the Fourth Amendment's pretty good. It provides basic protections. But under our own state constitution, which New Mexico and every other state has, we can provide greater protections under the state constitution than the feds offer under the fourth. We see a huge difference in New Mexico when it comes to search and seizure rights. Our courts basically say the Fourth Amendment's pretty good. It's basic. But under our Constitution, you guys should all know this, if you're a New Mexico officer, it's Article 2, Section 10. That is our version of the Fourth Amendment. That is the case law I'm going to talk about today. It's going to be addressing that. Our courts say, hey, under Article 2, Section 10, they don't say we give more. They don't say we give a little bit. They say far more expansive than the Fourth Amendment, far greater rights. And we see that in certain areas like what you can ask during a traffic stop. Under Arizona versus Johnson and federal law, if you stopped a vehicle for speeding, you can ask whatever you want, as long as you don't expand the length and the time and the scope of that stop and the time factor basis from what it would take a reasonable officer to investigate speeding. In New Mexico, you're strictly limited to questions related to the reason for the stop, unless you build reasonable suspicion to expand into a different investigation. That is a far cry different than the Fourth Amendment. That's a prime example of far greater protections being applied. Also think about automobiles. Now, under the Fourth Amendment, automobiles have a far less reasonable expectation of privacy because of the public aspect, traveling on the roadways. This goes all the way back to the Carroll case in the 1920s, bootleg and whiskey in my home state of Michigan. The Supreme Court created the automobile exception out of Carroll, where you, as an officer, if you have probable cause, there's evidence of a crime in a vehicle, it's readily mobile, there's 4 tires on it, you can search it without a search warrant. New Mexico strictly says, no way, not a chance. We provide far greater protections under the state constitution, and our courts often refer to a car as an extension of your home, meaning you have a far greater reasonable expectation of privacy in that automobile than the Fourth Amendment allows for vehicles. Again, a big difference from state law versus federal law. If you are a New Mexico officer, you have got to understand this interstitial approach, and you got to know the differences between how our court views the Fourth Amendment and Article 2, Section 10, because now we're going to bring it back together. In State versus Jim, we'll make a long story short here. This is about a year and a half, almost 2 years old now, I think. If we go back in New Mexico case law, there's been one area where the courts have not provided those extra special protections, and it's been in inventory. We have followed straight up Fourth Amendment inventory case law. When I was the HIDA attorney prosecuting drug cases, I rarely had inventories challenged. And when it was challenged, it was a simple Fourth Amendment analysis. I would refer to federal case law or New Mexico case law interpreting the Fourth Amendment, and it was straightforward, like I just mentioned. Did we have lawful possession? Did we follow policy and procedure? Was it reasonable? Did the officer stop and get a search warrant when they found the drugs? We were good to go. Never lost it. Never had that many file. State versus Jim, however, when the officer arrests the defendant for criminal trespass, inventories the vehicle, finds a little bit, I believe it was heroin. I have to go back to the original case and check. Found a controlled substance, Schedule 1. It's enough for a felony charge. Doesn't stop to get a search warrant and continue searching. Finds this locked gun safe underneath the driver's seat. At first, he's like, well, I'm just going to log it in because I don't have the keys. Then he realizes, well, Jim gave me the keys to his truck to get into it. One of these keys are probably for the safe. And sure enough, one of the keys is for the safe. He opens the safe, finds a gun, finds drugs, more charges. For the first time, the New Mexico court said, because they agreed this under the Fourth Amendment, that is a lawful inventory. We had lawful possession. Policy and procedure of the police department allowed the officer to search a locked container, and there's at least 2 cases that I know of federally that allow you to search in a locked container. This was lawful under the Fourth Amendment. However, our Court of Appeals decided in Jim that we are now going to depart from federal precedent. So now we're the one little area we had left in New Mexico where we just followed Fourth Amendment case law, it's going away. The court says from now on, we will apply the interstitial approach and we will give greater protections under the state constitution when it comes to inventories. Officially in State versus Jim. Now, why is this important? Because remember, we treat a vehicle as an extension of the home, meaning we have a far greater expectation of privacy now. If we're not operating under the Fourth Amendment and we're operating under New Mexico's constitution, now all of a sudden there's a whole different analysis that goes into what we can search in that vehicle. Because the inventory exception, it's always been this balancing test. The courts are saying, okay, let's balance your need as an officer to search that car, to protect you from claims of loss, to protect the defendant's stuff, versus the intrusion into the defendant's expectation of privacy. Well, under the Fourth Amendment, you have a far less expectation of privacy in your vehicle, but under New Mexico law, now all of a sudden it's an extension of your home. Now you have a very high reasonable expectation of privacy. That's going to affect the balancing test now on the court's analysis of how they're going to look at whether or not you can look in those containers. So State versus Jim, here's the takeaway. For the first time about a year and a half, 2 years ago, the Court of Appeals in New Mexico departs from federal law. We now apply those extra special protections. And the court talked about it's an automobile, greater expectation of privacy. Therefore, doing the balancing test, we don't think, officer, you needed to look in a locked container. So even though that's allowed under the Fourth Amendment, it's not allowed under our state constitution. You violated Mr. Jim's Article 2, Section 10 rights. It's suppressed, evidence out. And the takeaway is you can no longer search a locked container during an inventory under state law. All right, that was Jim. Let's get to the point here because I want to get to the point. Okay, now we're going to move on to State versus Sanders. It's February 2021. An officer, I believe this case is out of Lincoln County. It's the district court judge was Judge Sugg, so that's either Lincoln County or Alamogordo. So, at any rate, officer, the facts are pretty simple. The defendant is driving on a suspended license. The officer makes a traffic stop of the defendant. He's arrested because he's driving on a suspended license. And the car is in public. There's nobody to turn it over to. So it's a lawful inventory under the three-prong approach. They search the car, and in the back, they find in the trunk a black zippered pouch is how they describe it. To me, that could mean a backpack. It could mean a little tiny zippered pouch. It could be like my camera bag here sitting on the table. As a matter of fact, let's grab that and I'll show you guys. It could be like this, just a little black zippered bag. The way the court describes it, they start referring to it as a container. That's going to be important because of the holding here. So the officer opens the zippered pouch to inventory it. What's this? There's a bag of meth in there and paraphernalia. So extra charges. Now a misdemeanor driving on a suspended license has turned into a fourth-degree felony for possession of methamphetamine. So the defense attorney, of course, files a motion to suppress. And the defense attorney alleges, and this is a good argument, says, hang on a second, Your Honors. In State versus Jim, you said we're not following the Fourth Amendment anymore. We're now applying those greater protections under New Mexico law. Therefore, hey, vehicle's extension of your home. We don't think the officer should have been allowed to look in that zippered pouch because when you do that balancing test, they really didn't need to look in there. They could just, on the inventory, they could just say one zippered pouch and write it in that way. And that would protect them from a claim of loss, and it protects the defendant's stuff because we're still impounding it and sending it to the lot. Well, of course, the state responded, that's ridiculous. If you don't allow an officer to look in a container and the person alleges, hey, they stole my stuff, well, anybody that's done a jury trial knows what's the first question the jury's going to have. Hey, officer, did you look in that bag? They're claiming you stole this ring. Did you look in there to see if it was in there? Well, no. Why not? Well, that's complicated. So the court has to determine now, under a state constitutional law analysis, did the officer violate the defendant's reasonable expectation of privacy when he looked inside that zippered bag during an inventory? And the Court of Appeals determined, yes, the officer did violate Sanders' constitutional rights under the New Mexico Constitution, providing those extra rights because the greater expectation of privacy in the vehicle, the balancing test. The Court of Appeals reasoned and believed that you don't need to look in this bag because you could just log the bag in that way. Now, as a former trial attorney who's done quite a few trials myself, I don't understand that reasoning. Anybody who's been to a jury trial knows that really, I mean, legitimately, the jury is going to want to know if you looked in there, and that's why the Supreme Court, United States Supreme Court, would allow you to do so. However, our Court of Appeals has had to determine under the state constitution, which gives those far greater expectation of privacy, that It was just too much in the balancing test. And even though they recognize that, yeah, you would want that in a case, it's not outweighed. In fact, it's being outweighed by the intrusion into the defendant's expectation of privacy. So what does this mean? What are the takeaways? The court determined that the search of the pouch violated his constitutional rights. This is not a locked container like Jim. This is something like a little zippered pouch. So the court said that was a violation. Now, if you look at the reasoning here, if you can't look in that, if you can't look in this during an inventory, well, that means you can't look in a purse, you can't look in a backpack, you can't look in a wallet. I would say that it would reason to me, based on the holding, you cannot look in the center console, the glove box, or anything that can be articulated to be a container. If it is something that holds stuff in it and it is closed from your view, meaning they have passed the cat's reasonable expectation of privacy test, in any container, you can no longer look in it underneath this ruling. Now, I'm sure you guys are thinking, what? Yeah, my initial reaction was, do we even have an inventory exception anymore in New Mexico? And of course, when I thought about it, I'm like, okay, that's ridiculous. Of course, we still do. There's a couple things to point out. Number one, this only applies to automobiles. I don't believe this case would apply if you arrested someone who's walking down the street and they had a purse or a bag or a backpack, because the decision relies almost exclusively on the extra protections under the New Mexico Constitution when it comes to a vehicle, the reasonable expectation of privacy. If there's no vehicle involved, then this argument doesn't really exist. The other thing to think about is, yes, you can still open the car and you still have access to everything that's in plain view. So what should you take away as an officer? Number one, not just the state law, but we're seeing federally. Again, I referenced United States versus Ramos, a recent 10th Circuit opinion where the court suppressed evidence of a machine gun that was found during an inventory because the officer impounded an inventory of the vehicle that was recovered on private property without asking the private property owner if they wanted it towed. And again, the takeaway here is the courts want to see you as an officer using this as a community caretaker role. They don't want to see any indication that you are doing this inventory to find evidence of a crime. Now, if you find it in plain view, that's okay. But what do? You stop and get a search warrant. Now it's no longer an inventory, but you're searching pursuant to a search warrant, which makes it reasonable. So the big takeaway here is a couple things. Number one, you got to understand that this is a significant change in New Mexico law. This will significantly change the way that you do an inventory. You can no longer look in any container. And that's my interpretation of this case right now. That could change once we get a little more clarification from the courts, but it seems pretty clear to me. I mean, if you can't look in this, then what can you look in? Any container whatsoever, based on that reasoning, it's got to be out. So the other takeaway is come into it with a community caretaker mindset. You are not here to look for evidence of a crime. It's a public safety issue. You are doing this to just keep track of the valuables to protect yourself from claims of loss in the defendant's property. So with that said, I'm sure there's going to be a lot of questions about this case. Leave them in the comments below or reach out to me and let me know what questions you guys have. If you're a New Mexico officer, I've been going around the state. That's why I haven't had a chance to get these episodes out. We've been cranking out search and seizure training. If you have not got that training yet, the time has come to get it. Contact me and I will bring that training to your department. I'm also providing this training through some other agencies and organizations. So watch out, watch the website, leave a link down, tacticalattorney.com, where you can see when we're doing these trainings where we'll specifically cover New Mexico law. All right, guys, that's all I got for you. Big case, big change. Let me know what questions you have. Hey, as always, remember, you got to know this stuff because every battle's won before it's fought. So you guys stay safe, and I will see you guys on the next episode.